All right, I'll be presenting the first portion of this talk, so let's move to the next slide. Next slide, please. I think that was one too far there. Can you go back one? Perfect. So the learning objectives for this talk are, first, to understand the hierarchy of legislation. Second, know who's who in the contaminated sites legislative framework. Understand the use of director's discretion, especially in the issuance of a decision. And lastly, become familiar with compliance and enforcement. Next slide, please. Starting with the hierarchy of legislation, there are three broad levels of law in contaminated sites. At the highest level are laws passed by the Legislative Assembly in British Columbia. These laws are also called statutes. An example is the Environmental Management Act, also known as EMA. An act sets out high-level requirements and creates authority for subordinate legislation to be enacted, like regulations. A regulation fills out the details of an act. EMA gives authority to the Minister and Lieutenant Governor and Council to make regulations. An example that you may be familiar with is the Contaminated Sites Regulation, or CSR. Below regulations are protocols. EMA gives authority to the Director of Waste Management to establish protocols for specific purposes. Protocols prescribe procedural requirements that must be met unless they are specifically exempted. Requirements in all levels of legislation are legally enforceable, and those out of compliance may be subject to fines or other penalties. Next slide, please. On the note of legislation, I want to mention the rule of law. The rule of law is that everyone is subject to the law and no one is above the law. Not the Premier, not our Minister for the Environment, not the Queen, and not you or I. I bring this up because the land remediation section often receives inquiries or applications which seem to suggest that we have the power to grant exceptions to the law as it is written in EMA or the CSR. We do not have that power. Whether we agree or disagree with what is written in these laws, we must adhere to them and we must review applications in their light. That being said, EMA and CSR contain both mandatory and discretionary provisions. With discretionary provisions, the decision maker may exercise some choice in the outcome within the restrictions imposed by the regulation or legislation. Correspondingly, a qualified professional can also exercise some flexibility in judgment in how an application is prepared, again, within the framework of requirements in EMA, the CSR, applicable protocols, or any requirements imposed by the director. Next slide, please. So what is policy and how does it relate to legislation and the law? Policy is many things and it can be difficult to clearly define. A quote from a Supreme Court of Canada case at the top of this slide shows this, and it reads, "What constitutes a policy decision may vary infinitely and may be made at different levels." The ministry's statutory decision maker manual describes policy as direction intended to apply to everyone within reason in a normal range of circumstances. This is distinguished from law, which is described as rules intended to apply to everyone equally in all circumstances. With this in mind, we can add a few additional descriptors to policy. First, policy is written. It cannot be what one person said at a meeting. It must be written in a document somewhere. That could be a guidance document, information found on our website, or an announcement through the site remediation news. The application of policy is discretionary and it must be considered along the legal requirements. And third, policy evolves more quickly than law. Policy can evolve with advances in science, social circumstances, and/or a change in government. Policy can grow organically from ministry staff who bring it forward to management for approval as a result of ambiguity in the law, stakeholder concerns, or common complaints. Or it can be the result of top-down mandates to develop policy. An example of the latter is the ministry's mandate to create policy on climate change. Policy may be an agreed upon consistent interpretation of the law, and if it stands the test of time and the scrutiny of politicians, it may ultimately become the law. The law informs the development of policy, and policy in turn informs the creation of law. Next slide, please. Policy can become law in different ways. This process could be as simple as, sorry, excuse me. The process can be as simple as a document being moved to a protocol. For example, last year, part of Technical Guidance 15 was written into Protocol 1. Or policy can become law through the creation or amendment of an act or a regulation. This process involves extensive review, and the process varies depending on whether it is an act or a regulation. The slide here shows the general process for how this occurs for a regulation. The first step is a stage known as policy development. Policy development in the context here refers to scoping the problem, doing research, conducting jurisdictional scans, and engaging with Indigenous nations. Then there will be consultations with stakeholders on discussion and intentions papers. This will lead to a finalized policy proposal. There can be many iterations of this policy development stage. Number 2, once a proposal is written and reviewed by a government legal counsel, it will be sent to a drafting lawyer to draft legal language. 3, once the draft regulation is finalized, it will become part of the package that will be reviewed by the ministry executive before moving to the minister and/or lieutenant governor and council for final approval, which is step 4. The package contents are confidential. 5, lastly, the new regulation is deposited. At this point, the revised legislation moves to the Queen's printer for official printing of the law. The process time for moving from start to finish can vary. It can take anywhere from a year for simple changes to 5 or more years for complex changes. Next slide, please. Now that we have some understanding of law and policy, we'll move into those who are subject to the law and those who oversee the law as regulators. The 7 boxes that you see on this slide represent the 7 key roles within the contaminated sites framework. It might be helpful to think of these as the key players in contaminated sites. Within the ministry, that's the yellow players, are 4 important roles: the Director of Waste Management, the Program Director, the Statutory Decision Maker, also known as the Decision Maker or Delegate of the Director, and the Ministry Reviewer or Technical Expert. External to the ministry, which is what you see in the blue, are 3 key roles. These are the responsible person, the qualified professional, and the contaminated sites approved professional. In the next slides, we'll discuss the responsibilities and relationships between each of these roles. Next slide, please. To really understand these key roles, you need to know that the ministry is organized in both an operational sense and in a regulatory sense. Many people within the ministry wear 2 hats. That is, they have both a regulatory role and an operational role. This slide shows how the ministry is organized from an operational standpoint. The current Minister of Environment and Climate Change, the Honourable George Heyman, is an elected official and takes direction from Premier and Cabinet. The Deputy Minister is the most senior public service employee in the ministry. And under the Deputy Minister are several Assistant Deputy Ministers, each of whom oversees several Executive Directors. And in turn, below them is our Program Director, who leads the land remediation section shown in the yellow box. Operationally, the land remediation section is organized like many companies are. There's a director, and under the director are managers, and under the managers are various staff. The key role that I want to draw attention to here is the Program Director, who plays a very important role in our section operationally. The other key roles are here as well, but they don't become apparent until we describe the organization in a regulatory sense, which is what I'm going to do on the next slide. Next slide, please. From a regulatory perspective, the Minister of Environment is also the minister responsible for the Environmental Management Act, and they can designate power under EMA to a Director of Waste Management. Directors of waste management under EMA typically hold the organizational role of executive director. A director of waste management can, in turn, delegate some power under the Environmental Management Act to appropriately trained staff. These individuals become statutory decision makers. As you can see, there are many statutory decision makers in the land remediation section. Another key role that you can see on this organizational chart is ministry reviewer. Staff can act as both reviewers and decision makers, but never both on the same application. Next slide, please. Let me introduce you to the key roles one by one. The first role I'm going to describe is the Director of Waste Management, also known as the DWM. Within the ministry, there are 3 Directors of Waste Management. Kevin Butterworth is the DWM responsible for contaminated sites. Operationally, Kevin oversees program directors as an executive director. In this case, he oversees program directors for both environmental emergencies and the land remediation section. Under the Environmental Management Act, Kevin has been designated a Director of Waste Management by the Minister. This is important because the Act is largely carried out through the powers of a Director of Waste Management. As I mentioned on the last slide, EMA confers power to the Director, and in turn, the Director may delegate powers to others known as decision makers or Director delegates. However, there are limitations to the power that a Director can delegate. For example, only the Director of Waste Management can establish protocols under the Act. Next slide, please. You've probably noticed that I've used the word director with several different individuals already. To clarify some confusion, the Director of Waste Management, Kevin, who was shown on the previous slide, is not the same as our Program Director, Danielle, shown here. The Program Director is an operational role, and the individual in that role manages and directs priorities for the land remediation section. These priorities are set very broadly by the Premier in a mandate letter to the Minister. The mandate letter is strategically broken down to the Ministry's service plan annually, and the Program Director delivers priorities based on this plan. The Program Director is charged with staffing, training, and delivering on core business and special projects for the program. The Program Director is not the Director specified in the Environmental Management Act, but she is a delegate of the Director, also known as a decision maker. Next slide, please. I'm going to switch gears very slightly here and describe the rest of the key roles in the context of an application. A responsible person is shorthand for a person responsible for remediation of a contaminated site. In other words, the responsible person is the individual, company, or corporation who holds liability for remediation. It can be a current or previous owner or operator, someone who produced a substance, someone who transported a substance, or somebody who handled the substance in a manner that created a contaminated site. A responsible person is responsible for meeting applicable requirements of the contaminated sites legislation, but they are generally not experts in contaminated sites. For this reason, they typically hire a qualified professional to navigate the application process on their behalf. Next slide, please. As I said, the qualified professional will prepare an application and any associated reports on behalf of the responsible person. A qualified professional, also called a QP, is a registrant of a regulatory body under the Professional Governance Act, who may be reasonably relied upon to provide advice or services within their regulated practice. These individuals may be professional geoscientists, engineers, biologists, or other licensed professionals. In addition to being a professional who prepares applications, a qualified professional is also considered a foundational qualification. For example, many ministry reviewers, approved professionals, and decision makers are also qualified professionals. Next slide, please. Once an application has been submitted by a qualified professional, it will move to review. There are 2 potential reviewers, as Lucy earlier touched on, either a ministry reviewer or a contaminated sites approved professional. A ministry reviewer will review an application and provide an assessment for the director's consideration. Specifically, they will provide an opinion on compliance with applicable regulatory provisions and on the technical and scientific merit of an application. Ministry reviewers will correspond with an applicant to seek any necessary clarifications or to obtain any missing pieces of information. Once the ministry reviewer is able to complete their review and assessment, their opinions are provided to the decision maker. Next slide, please. The alternate review path is through an approved professional. Approved professionals, or APs, perform many of the same review functions that were just mentioned for a ministry reviewer, but the legislative framework specifies that they are generally only reviewers for non-high-risk sites. APs are external to government. They are individuals appointed to the roster by the director under the authority of the Environmental Management Act. An approved professional is a qualified professional who has a specified minimum level of experience and who has passed an exam administered by CSAB. Although APs are appointed to a roster by the director, they are not delegated any authority to make decisions under the Act. They are only able to make recommendations to the director. Another note here is that many approved professionals also practice as qualified professionals on numerous and varied contaminated sites. As with an application that is reviewed by a ministry reviewer, an application reviewed by an AP moves to a decision maker for consideration once their assessment is complete. Next slide, please. The decision maker reviews an assessment and makes an unfettered decision to approve or not approve an application. As I previously touched on, a decision maker is an individual within the ministry who has been delegated the authority to act on behalf of the Director of Waste Management. When you receive a statutory decision from the ministry, it is signed for Director, Environmental Management Act, by a delegate of the Director of Waste Management. A decision maker, as I mentioned on the org chart slide, can be a range of people and includes our program director, managers, and senior technical staff who are in officer roles, and also the Director of Waste Management. So that's it for me. And at this point, I'm going to pass it over to my colleague, James. So James, I'll let you take it away.
All right, thanks, Ingrid. As Ingrid has just finished explaining, directors under the Environmental Management Act, or the Act, play a key role regarding site remediation in British Columbia. During my presentation, as outlined on the current slide, I will review the designation of Director of Waste Management, or GWM, and the GWM's delegation of authorities to other statutory decision makers, or SDMs, and where these authorities come from in the Environmental Management Act, along with examples. I'll also go over the role of a statutory decision maker and the process they use when making decisions under the Act. Next slide, please. As a reminder, and as Ingrid has already described, it is the minister who designates directors of waste management under the Act. GWMs, in turn, may delegate all or some of their authorities to other government staff. These individuals would then be known as delegates of the director, or simply the director. Both the DWM and delegates are statutory decision makers, or SDMs. Next slide, please. In the next few slides, I'll provide examples of the authorities given to a director under the Act. Under EMA Section 41.1, a director may order an owner or operator of a site to undertake a preliminary site investigation or a detailed site investigation and to prepare a report of the investigation under specified conditions and terms. Under EMA Section 44.1, a director may determine whether a site is a contaminated site. If the site is a contaminated site, the director may determine the boundaries of the contaminated site. And under EMA Section 48, the director may order a person to prepare and provide a site disclosure statement. When requiring actions to be carried out, the director is informed by the legislation as to who may be ordered and what they may be ordered to do. Directors do not have unlimited authority. They must carefully review the authority given to them under the Act and any delegation they may have been given. Next slide, please. More examples of discretionary powers of the director include certifications such as approvals in principle, or AIPs, as described in EMA Section 53.1.1. a director may issue an approval in principle stating that a remediation plan for a contaminated site, A, has been reviewed by the director, B, has been approved by the director, and C, may be implemented in accordance with the conditions specified by the director. And certificates of compliance, or COCs, EMA Section 53.3. A director may issue a certificate of compliance with respect to remediation of a contaminated site. A director may impose requirements on persons carrying out independent remediation under EMA Section 54.3d. A director may, at any time during independent remediation by any person, impose requirements that the director considers are reasonably necessary to achieve remediation. Also, a director may issue a remediation order under EMA Section 48.1, requiring a responsible person to remediate a site to meet applicable environmental quality standards. Next slide. And now I'll provide a brief overview of how a director, or SDM, proceeds to a decision and what important factors must be considered. Information is provided to an SDM, or director delegate, by either the applicant or qualified professionals and/or internal regulatory staff in the form of a technical review. The statutory decision maker must ensure that only the information relevant to the decision is considered and that this information is given an appropriate weight. When an SDM has to make a decision, the SDM will have to weigh the evidence and decide which evidence is most convincing and then apply their discretion fairly and independently. Statutory decisions must be unfettered and made without constraints. Next slide. In exercising discretion, the rules of administrative law apply to the SDM. These include natural justice, procedural fairness, and the reasonable apprehension of bias. The next few slides will briefly describe each of these rules. Next slide. When making a statutory decision, an SDM must follow the rules of natural justice, including giving the applicant the opportunity to be heard. In the majority of instances, SDMs are making decisions based on applications voluntarily submitted by persons seeking such things as certifications or other approvals. In these cases, the primary opportunity to be heard is provided by the SDM fully considering the application materials. Should the SDM or his or her supporting ministry reviewers require clarification or provision of additional information in connection with an application, then further opportunity may be provided to an applicant. In non-voluntary circumstances, for example, if a director considering the possible need to issue an order, then natural justice requires the director to provide an opportunity for the person who may be ordered to make submissions on the matter for the director's consideration before any final decision is made. The person is also entitled to know all of the information that the SDM uses to come to any decision. When an application has been submitted, the SDM considers all relevant information provided by an applicant in making the decision. This includes the review performed by the ministry reviewers. Finally, a decision maker, or SDM, may provide reasons for the decision in the form of a decision letter. In approval letters for protocols, for example, the rationale for why the decision was granted is included in the decision letter. Next slide. There is a distinction between the duty to act fairly and the rules of natural justice. The duty to act fairly applies to the fairness of the procedures leading to any discretionary decision. This principle applies even though there may be provisions for an appeal of the decision. This also includes affected property owners and other stakeholders, giving them the opportunity to be informed and provide any comments before any decisions are made. Please remember that each decision is site-specific. Next slide. Procedural fairness and the principles of administrative law require that the decision maker not be biased or have the appearance of being biased. For example, ministry staff who review application materials do not also act as the statutory decision maker on the same application. Next slide. When an SDM makes a decision on an application, or other contaminated sites matters, it is done in writing. Furthermore, the information that is the basis of the decision and the reasons for the decision are normally explicit in the written decision. Should requirements be imposed as part of the decision, those are specified, as are any limitations or qualifications to the decision. Should a person believe they are aggrieved by a director's decision, they may appeal the decision to the Environmental Appeal Board as established under the Environmental Management Act. Next slide, please. Here are examples of different decisions that an STM can make, including approvals in principle, certificates of compliance, final determinations of not a contaminated site, and investigation orders. Next slide. If the person subject to the decision feels aggrieved, an appeal process may begin following the statutory decision. The person that was aggrieved by the decision, either someone affected in the public by the decision, or the person subject to the decision, such as a property owner, they have 30 days to file their appeal. There is then a hearing by the Environmental Appeal Board, or EAB, which can be in writing, orally, or a combination of these. After the hearing, the decision is made with 3 possible outcomes. 1, the original decision is either confirmed, varied, or rescinded. 2, the decision is sent back to the original decision maker with directions on how to proceed. Or 3, the EAB can make any decision it feels is appropriate based on the original decision maker's authority. Next slide. At the conclusion of the appeal process, the board issues its decision and any associated direction or requirements. Should any party be unsatisfied with the outcome, they may consider applying to the Supreme Court for a judicial review of the decision pursuant to the Judicial Review Procedure Act. There are very few judicial reviews undertaken for decisions under EMA. Decisions of the EAB that have undergone a judicial review are posted on the EAB website. For more information or to access these decisions, go to the EAB website as shown on the screen at www.eab.gov.bc.ca. Next slide. So once a decision is made and a person is responsible for meeting any requirements, it's the job of ministry staff to verify compliance and, if necessary, enforce compliance. The ministry has established policies and procedures for compliance and enforcement, which are published on its website for responsible persons and others to review. The policies and procedures are an evidence-based, risk-prioritized approach to compliance and enforcement, which underlies the other efforts the ministry makes to promote compliance with environmental regulations and directors' requirements, such as website information and public presentations like this one. Next slide. So that concludes this presentation. Let us know if there are any questions, or if we don't have time, or you want to send them to the email address on the screen here at remediationfaqs@gov.bc.ca. In closing, here's a summary of some of the key concepts from the presentation. Acts, regulations, and protocols are legally enforceable. There are many key roles in the contaminated sites regulatory regime in British Columbia. A director delegate, or SDM, has discretionary authority to make decisions as defined in EMA. And when making decisions, SDMs must follow the rules of administrative law. Thank you.